Hello, my name is Sanaya Moore.
And my name is Emmy Beth Orlichek, and today we are looking at religious freedom, specifically in the case Bowen versus Roy, decided in 1986.
First, we're going to start off with the parties in the case. Our plaintiffs are Stephen Roy and Karen Miller. They're the parents of a young child who practice Native American spirituality. Their role, their role in this case is challenging a government requirement based on their religious beliefs. Our defendant in the case is Otis Bowen, which at the time was the Secretary of Health and Human Services. His role in our case is enforcing Social Security number policy.
So now that we know the parties in this case, we can take a look at the basic facts of the case. So, first, the Roy family applied for government benefits, specifically Aid to Families with Dependent Children Program, or the AFDC, and the Food Stamps Program. For both of these programs, the government required a Social Security number for their child. The family refused because, as they practiced Native American spirituality, they believed that assigning a Social Security number would harm their child's spiritual well being. As a result, the benefits were denied without them having the Social Security number. This led to the family suing, claiming that their religious freedom was being violated.
Moving on to some legal issues related to the religious freedom. The main question in the case is, does requiring a Social Security number violate the free exercise clause of the First Amendment? The key concept in this case is the Free Exercise Clause, which protects individuals' rights to believe and practice their religion freely, while also allowing the government to regulate actions that conflict with natural laws. The core issue in this case is, can the government require individuals to comply with the neutral policy, even if it conflicts with their religious beliefs?
Before we move on, we just wanted to dive deeper into the Free Exercise Clause. So it can be found in the First Amendment of the United States Constitution, which states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. The Free Exercise Clause forbids Congress from prohibiting the free exercise of religion. In Cantwell versus Connecticut, decided in 1940, the court explained that the religion clauses embrace two concepts: the freedom to believe and the freedom to act. The first is absolute, but in the nature of things, the second one cannot be.
Moving on to the Supreme Court decision, the court ruled against the Roy family. The court decided that the government did not violate the Free Exercise Clause by requiring a Social Security number. A key part in the court decision was the distinction between belief and action. Individuals are free to believe whatever they want, but the government is not required to alter its administrative processes to match religious practices. Allowing exemptions can make government systems unworkable, creating administrative confusion.
So, when looking at this case, our group concluded that we agree with the court's decision. The government has to stay organized. Religious rights do not give somebody the right to prohibit how the government keeps its own files or records. To be fair, laws must apply to everyone. If everyone skipped rules based on what they believed, the system would stop working. Social security numbers are just tools that help prevent fraud and make sure that the money is going to the right family.
In conclusion, for the Bowen versus Roy, the court decided this case by deciding that the government can use ID numbers to run its programs, even if a person disagrees for religious reasons. The government will keep using the same rules for everyone to make sure the system stays organized and honest. This makes it easier to stop people from cheating the system and ensures that money is handled correctly.
So, one similar case that we decided to look into was the Trinity Lutheran Church of Columbia Inc. versus Calmer, decided in 2017. So, first, just to look at a summary of the case, some of the key facts include that a Missouri program was offering grants to nonprofits to resurface playgrounds using recycled tires. A preschool that was run by Trinity Lutheran Church applied for this program, but they were denied solely because they were run by a religious organization, based on a state constitutional rule prohibiting public funding to churches. The church ended up suing, arguing that this violated the free exercise clause of the First Amendment. And then just to look at the court's decision, the US Supreme Court ruled in favor of the church, holding that denying an otherwise available public benefit just because of religious status is unconstitutional. And the primary holding for this case states that a church may not be denied an otherwise generally available public benefit, like a government grant, because of its religious status under the First Amendment.
Now that we know about both cases, Bowen versus Roy and Trinity Lutheran Church of Columbia Inc. versus Comer, we have decided on some similarities and differences in the two cases. Some similarities that we have are both cases involve the free exercise clause of the First Amendment. Both cases ask the question, when does government action improperly burden religious practice? In both cases, individuals or organizations were trying to receive a government benefit, but faced barriers connected to religion. Some differences we've decided were the type of rule. Bowen versus Roy allows neutral administrative requirements, social security numbers, while Trinity Lutheran Church of Columbia Inc. versus Comer rejects rules that exclude applicants because they are religious. Some burden on religion is Bowen involves an indirect burden, government procedure conflicting with beliefs, while Trinity Lutheran involves a direct penalty for religious status. The constitutional outcome was Bowen permits the government to prioritize uniform program administration, while Trinity Lutheran requires equal access to public benefits regardless of religion.
So, in conclusion, um, we discovered that the free exercise clause gives a complete freedom to believe, but does not give the complete freedom to act in every case, just due to the nature. In Trinity Lutheran Church of Columbia Inc. versus Comer, the court ruled that excluding a church from a public benefit due to its religious status is against the Constitution. In Bowen versus Roy, the government has to require individuals to comply with certain neutral policies, even if they do not align with their religious beliefs.
Overall, these cases show how the Supreme Court continues to define the balance between government power and religious freedom. Thank you.